we'll now go to Megan. Megan is from Australia. She has a degree in law and a PhD in hermeneutics and interpretation. She's worked in policy, research, and project management, and has taught at school and university. Megan's advocacy work has focused on women's rights and refugee support. She's currently working with the Feminist Legal Clinic and groups including Sex-Based Rights Australia, and is going to continue to tell us about the WDI submission to the International Criminal Court, policy guidelines on gender persecution. So thank you so much, Megan, and over to you.
So I'm going to follow on from Dianne and talk about the history of the idea of gender in those ICC instruments and how it actually was quite sensible, but has evolved into something problematic and that can be perverted by member states to replace sex or entrench sex stereotypes, which is, of course, the opposite of what the mandate is. So as Dianne said, the OTP, Office of the Prosecutor, is redeveloping the 2022 policy on gender-based crimes. That was itself a reassessment of the original 2014 policy. So the 2014 policy was called the Policy Paper on Sexual and Gender-Based Crimes, and the 2022 was renamed the Policy on the Crime of Gender Persecution. Since then, we've had a 2023 policy on gender-based crimes partly revised. And so the current policy under development is intended to harmonise with that 2023 update rather than entirely supplant it. So this idea of gender persecution is based on the Rome Statute, which came into force in 2002. The statute established 4 key international crimes, including crimes against humanity. It established the International Criminal Court, and it was the first international instrument to expressly recognise the gender and sex-based element of crimes against humanity and war crimes. So it defines gender like this. It says, for the purpose of this statute, gender is understood to refer to the two sexes, male and female, but within the context of society. So the statute doesn't list sex as a separate ground protected from persecution, however, which means that only the persecution based on the social gender norm context of society is technically covered. Now, this was actually improved with the 2014 policy. This was adopted by the Office of the Prosecutor to guide its work enforcing the statute. Now, the treatment of sex and gender under the 2014 policy, which is now superseded by the 2022 revision, was based on the WHO's legal tools info sheet on gender, women, and health. What do we mean by sex and gender? Now, this info sheet is written in language that can easily be understood by a wide range of people, and it logically differentiates between the relevant categories of sex and gender in a way that I think is comprehensive and fair. So the info sheet says that sex refers to biological and physiological characteristics that define men and women, but it says that gender refers to the socially constructed roles, behaviours, activities, and attributes that a given society considers appropriate for men and women, and says that male and female are therefore sex categories, while masculine and feminine are gender categories. So it gives some examples of sex characteristics. So it says women menstruate while men do not, men have testicles while women do not, women have developed breasts that are usually capable of lactating while men have not, and it even says men generally have more massive bones than women. It also gives some very sensible examples of gender characteristics. It says in the United States and most other countries, women earn significantly less money than men for similar work. In Vietnam, many more men than women smoke, as female smoking has not traditionally been considered appropriate. In most of the world, women do more housework than men. So this accords with other UN statements, such as from the Committee on the Rights of Persons with Disabilities and the CEDAW Committee, which in General Recommendation number 28 in 2010 says sex refers to biological differences between men and women, gender refers to socially constructed identities, attributes, and roles for women and men in society's social and cultural meaning for these biological differences, resulting in hierarchical relationships between women and men. So it talks about the impact on the distribution of power and rights favoring men and disadvantaging women as a result of gender. So this 2014 policy is called the Policy on Gender-Based Crimes, but the use of gender in it is not really that bad because it's not used in a way that tries to slide into or erase the category of sex. The definition of gender-based crimes in the policy is inclusive of sex. It says that gender-based crimes are those committed because of a person's sex and or socially constructed gender roles. The problem is that in 2022, they removed this reference to sex and began to speak only of gender. And they also began to conflate categories. So 2022 is when the initialism LGBTQI+ began to be used, especially in sentences like women, girls, men, boys, and LGBTQI+ persons, which of course is suggesting that LGBTQI+ is one coherent group with common characteristics and interests. It's also suggesting that people such as lesbians or gay men within that group are somehow different from women, men, girls, and boys. Secondly, from 2022, characteristics that are not really gender norms begin to be included in the category of social constructs and gender norms. For example, the 2023 policy lists sexual orientation and even the words woman and man in its examples of gender constructs, social constructs. It even lists gender identity, which of course is not meant to be a social construct. Thirdly, the definition of gender-based crimes is also narrowed in the 2022 policy to exclude the ground of sex that was, of course, in the 2014 one. So the new definition simply says that gender persecution is the crime against humanity of persecution on the grounds of gender. And lastly, the 2022 policy, also limits this even further to saying that persecution is always punishment for gender non-conformity. It completely ignores the aspect of gender persecution that is actually the enforcement of oppressive gender norms against even gender-conforming women. China, India, Pakistan, and other countries have not practiced female infanticide as a punishment because girl babies were too masculine. Women are not raped in war as a punishment for being insufficiently feminine. It's ridiculous. So the 2023 policy goes even further than simply removing sex in favour of gender and begins to rely on the concept of gender identity as a replacement for both sex and gender. For instance, one footnote kind of slipped in the bottom of the page says, inspired by the gender persecution policy, this policy notes that the quote, men and women includes some LGBTQI+ individuals, while other non-binary LGBTQI+ persons may not identify as either. Now, that footnote conflates categories to produce a meaningless statement that flies in the face of accepted ICC policy definitions that it itself references by asserting that the phrase men and women is actually no longer a reference to sex. Instead, it claims that only some people in the LGBTQI+ group are male or female. And of course, the implication is that the male and female sexes, rather than being material biological qualities, are in fact things that, humans can opt into or out of depending on the way they wish to identify at any given time. So it's statements like these that are now permitting member states to obviate the sex-based rights of women and girls with impunity. So, for example, in the recent Australian case of Tickle and Giggle, the Federal Sex Discrimination Commissioner intervened to submit to the Federal Court that the word sex is not a biological concept, referring to whether a person at birth had male or female physical traits, nor is it a binary concept limited to the male or female sex, and that it is broad enough to encompass the idea that a person's sex can be changed. So the commissioner refuted the distinction pled by Giggle between sex and gender. Giggle essentially pled a version of the distinction under international law, the Rome Statute, the 2014 ICC policy. This version of international law pled by Giggle was rejected by the Australian Human Rights Commission and the Sex Discrimination Commissioner, and sex was said to be determined by a person's expressed gender or claimed gender identity. And the federal court affirmed the commissioner's interpretation. The judgment outlined the meaning of sex under the law, saying, yes, it was not a biological concept. It was not a binary concept. And they said that now the word sex took a broader ordinary meaning informed by its use in, for example, international law. So the term gender was chosen for the Rome Statute for the very purpose of ambiguity and openness. So the fact now that the elasticity is being exploited is not an accident. It's now the term being favoured by member states in favour of the more concrete term sex because of that. So, for example, during the International Law Commission's April 2024 session on the draft articles on prevention and punishment of crimes against humanity, the quorum actually agreed to leave out the Rome Statute's definition of the word gender. The stated reason for leaving the term undefined in the new draft articles on crimes against humanity was to allow the term to be applied based on an evolving understanding as to its meaning. Portugal, for instance, noted that they welcomed the removal of the definition of gender because they said it allows great flexibility compared to previously adopted solutions. And Australia, of course, thoroughly approved it, saying that it enables states to apply the definitions that are used within their national systems. Now, I mean, the national system of Australia uses a very different definition of gender from the Rome Statute and has instead chosen to define it as the determinant of legal sex, untethered completely from biological sex. So this has allowed Australia, for instance, to effectively eliminate the consideration of sex-based rights when defined biologically as distinct from gender norms or self-declared identities. So it's for these reasons that we're pushing back against the trend, which I would call a devolution, seen from the original 2014 document to the current policy, and urge the prosecutor to reverse that trend, which, since it was pretty well stated in their original policy, I think is a reasonable goal. Thanks very much.